Welcome to the deep dive. Today we're getting into the weeds of borrowing rules specifically, who lenders can actually lend to. It's not just about credit scores.
No, it really isn't. It's about legal categories, permissions, protections, a whole framework. It changes significantly depending on whether the borrower is, say, a person or a company.
Right. And that's where we'll start with the business side of things, corporate entities.
Good place to begin.
Okay, so imagine a limited company wants a mortgage. Maybe a small business buying its premises. What's the fundamental difference compared to me getting a mortgage on my house?
The biggest difference, regulation, or rather the lack of it for the company. Corporate mortgages, loans to a company, are generally not regulated by the FCA.
Not regulated at all, even if it's for, say, a residential property the company plans to rent out.
Correct, because the loan is to the company, the legal entity, not an individual consumer. So those detailed FCA affordability rules, the MCOB rules we often talk about, they just don't apply in the same way.
So if I set up an SPV, a special purpose vehicle, specifically to buy rental properties, that mortgage wouldn't be a regulated consumer buy-to-let.
Exactly. It falls outside that specific consumer protection net because the borrower is the corporate body.
Okay. But the lender still needs to do some checks, surely. They're not just handing over cash.
Oh, absolutely. They have their own due diligence, just not mandated by the FCA's consumer rules. They need to protect their own interests.
And what does that involve? What are they checking?
Two main things, typically. First, they need to see the company's constitution, its memorandum and articles of association to confirm the company is actually allowed to borrow money.
Makes sense. And the second?
They need proof that the individual representing the company, the director signing the papers, actually has the proper authority from the company to commit it to that loan. Internal governance checks, essentially.
Okay, so they check the company's paperwork. But isn't there a catch for the people behind the company, the directors, shareholders?
Ah, yes. The personal guarantee. This is key. Because the company is a separate entity, directors have limited liability, in theory.
In theory.
Right. But in practice, especially with smaller companies, lenders almost always insist on personal guarantees from the directors or main shareholders.
And these aren't just promises, are they?
No, they're often secured. Frequently, the lender will require a legal charge over the director's own main residence.
Wow. So you bypass the consumer mortgage regulations for the company loan, but the director ends up putting their own family home on the line anyway.
That's very often the reality, yes. It transfers the ultimate risk back to the individuals involved.
Okay. And does a similar logic apply to commercial mortgages? Say, a loan for a shop or a factory?
Generally, yes. A mortgage secured on purely commercial property is also usually not a regulated mortgage contract.
So, again, no standard FCA affordability assessment like for a residential mortgage.
Correct. There's a small technical exception. If less than 40% of the land area is intended for use with a dwelling, some rules might kick in. But for typical commercial loans, no. Lenders look elsewhere.
Where do they look? What's the focus?
The business plan, its viability, the track record, the projections. Does the commercial venture itself look like it can sustain the debt? That's the primary concern.
Okay, that clarifies the business side. Now, let's shift gears completely. This is where I think it gets really complex and, frankly, quite human.
Yeah.
We're talking about specific FCA categories for individuals needing special treatment.
Yes, two really important ones. Mortgage-trapped borrowers and vulnerable customers.
Let's start with mortgage trap, sometimes called mortgage prisoners, right?
Mm-hmm.
Who are they?
They are customers who already have a regulated mortgage. They're keeping up with payments, doing everything right, but they can't switch. They can't move to a new lender or even sometimes get a better deal with their current lender because they wouldn't pass today's stricter affordability checks, the ones brought in under MCOB.
So they're stuck paying potentially higher rates just because the rules changed after they took out their original loan. That seems unfair.
It's a very difficult situation, and the FCA has introduced specific rules to help, but they are quite narrow.
How narrow? What can these rules actually be used for?
Okay, they can only be used if the borrower wants to switch to a new arrangement without borrowing any more money and without increasing their costs. So a like-for-like switch, basically, either internally or remortgaging externally.
Right. Just easing the current burden, not taking on more.
Precisely. And crucially, this is a really important point, these specific rules cannot be used if the borrower wants to move house.
Wait, so if our mortgage prisoner, let's call him Jai again, finds a smaller, cheaper house that would actually lower his outgoings, he can't use these rules to get a mortgage for that new place.
No, that's explicitly excluded. The rules are purely for managing the existing mortgage situation on the current property. They don't facilitate moving.
So it's like a financial lifeline, but it's tethered. You can't swim to a new shore with it.
That's a good way to put it. Very limited scope.
Okay. Let's move to the other category. Vulnerable customers. This sounds broader.
It is. The FCA defines a vulnerable customer as someone who, due to their personal circumstances, is especially susceptible to harm or detriment, particularly if firms don't act with appropriate care.
And the FCA gives guidance on what makes someone vulnerable.
Yes, their 2021 guidance identifies 4 key drivers. It's not just about finances.
What are they? Can you break them down?
Sure. First is health. Physical or mental health conditions that impact someone's ability to manage their affairs day to day.
Okay, makes sense.
Second, life events. Things like bereavement, losing a job, a relationship breaking down. The guidance specifically flags bereavement as a key event requiring firms to be extra careful.
So major life shocks that understandably affect financial capacity.
Exactly. Third is resilience. This is about someone's ability to withstand shocks, both financial and emotional. Low savings, erratic income, lack of support networks could contribute here.
Right, their buffer, essentially.
And fourth is capability. This covers things like low financial knowledge, lack of confidence managing money, poor literacy or numeracy, or even low digital skills in today's world.
And are there specific types of mortgages that automatically raise a vulnerability flag for lenders?
Yes, certain products are seen as inherently higher risk or more complex, suggesting the customer might be more vulnerable. Things like statutory right to buy schemes, sale and rent back arrangements.
Which have a troubled history.
Indeed. Also, equity release products and debt consolidation plans, especially if they involve securing previously unsecured debts against a property.
So if a customer fits these criteria or is using these products, what does that mean for the lender or broker? What do they have to do?
It means they need to step up. They have to tailor their communication and service. Staff need training to recognize and respond appropriately. They need flexible processes. And importantly, they need to monitor outcomes to ensure they are genuinely meeting the needs of these vulnerable customers. It's an ongoing obligation.
Okay, that covers extra protections. Now let's look at groups who face actual restrictions on borrowing, often due to law or circumstance.
Right. The main ones covered in the material are minors, people lacking mental capacity, and undischarged bankrupts.
Minors and mental capacity seem relatively straightforward.
Yes, broadly. In England, Wales, and Northern Ireland, someone under 18 can't hold a legal estate in land, so they can't take out a mortgage in their own name. For someone lacking mental capacity, their financial affairs, including borrowing, must be handled by someone legally appointed, either a deputy via the Court of Protection or an attorney under a relevant power of attorney.
Okay, let's spend a bit more time on insolvency and bankruptcy. What's the key difference between just being insolvent and being formally bankrupt?
Insolvency is more of a state of being you can't pay your debts as they fall due, or your liabilities outweigh your assets. Bankruptcy is the legal process that follows, usually initiated by a court order.
And there's a minimum debt level for that order.
For a creditor to petition for someone's bankruptcy in England and Wales, yes. The undisputed debt generally needs to be at least £5,000.
Once that order is made, what happens?
Things move fast. A trustee in bankruptcy is appointed. Their job is to take control of the bankrupt's assets, including property, potentially sell them, and distribute the proceeds to creditors according to specific rules. They do have to allow for a basic standard of living, but asset seizure is the core purpose.
And how long does the bankruptcy status itself usually last?
The typical period of bankruptcy is 12 months, after which the person is usually discharged. However, it can be extended if the person doesn't cooperate, but the consequences last much longer.
Okay, let's focus on that period before discharge. Can an undischarged bankrupt buy property or get a mortgage?
Generally, no. They are legally barred from obtaining an interest in property. Getting a new mortgage is basically impossible. Even getting a further advance on a property they might already own, while technically perhaps possible in some obscure scenario, would be incredibly difficult as lenders will run a mile.
Is there any scenario where they can borrow while undischarged?
There's one very specific small allowance. They can legally borrow amounts less than £500.
Only £500.
Yes, but crucially, they must disclose the fact that they are an undischarged bankrupt to the lender before they take out the loan. Failure to do so is an offense.
Okay, so after the 12 months, they're discharged, free to borrow again.
Legally, yes, they are discharged and can enter into contracts, but the bankruptcy remains on their credit file
For how long?
for 6 years. 6 full years from the date the bankruptcy order was made.
6 years is a long shadow.
It really is. They'll have to declare it on any mortgage application during that time, and it will significantly impact their ability to get credit and the rates they might be offered.
Are there formal alternatives to bankruptcy that might be less severe?
Yes, the material mentions two main ones: individual voluntary arrangements, or IVAs. That's a formal agreement with creditors to pay back a reduced amount over a set period, usually 5 years.
Okay, and the other?
Debt relief orders, or DROs. These are for people with lower levels of debt, currently under £50,000 fewer assets, and not homeowners. If granted, the debts are usually written off after 12 months. It's a sort of bankruptcy light for specific circumstances.
Right, so different pathways depending on the situation. Now, finally, let's talk about planning ahead. What if someone is worried about losing capacity in the future? Powers of attorney.
Exactly. A power of attorney, or POA, is a legal tool. The donor, the person giving the power, appoints an attorney, someone they trust, to make decisions or act on their behalf.
But who can be a donor? Can anyone set one up?
The donor has to have mental capacity at the time they create the POA, and someone who lacks legal capacity themselves, like a minor, can't appoint an attorney.
Okay. Now, the types of POA can be confusing. There are different ones for different situations, aren't there?
Yes. The key is understanding when they are valid and what happens if the donor loses mental capacity. There's the ordinary POA. Think of it as a convenience tool. You might give someone an ordinary POA to manage your bank account while you're traveling, for instance. It's only valid while you, the donor, have mental capacity. The moment capacity is lost, it automatically ceases to be effective.
So it's no good for planning for potential dementia or similar issues.
Absolutely not. That's where the lasting power of attorney, the LPA, comes in. This one is specifically designed to continue, or sometimes start, even after the donor loses mental capacity.
The LPA sounds like the crucial one for future planning.
It is, but there's a vital step. It must be registered with the Office of the Public Guardian, the OPG, before it can be used. Think of registration as activating it.
And there are different types of LPA.
2 types. One for property and financial affairs. This covers things like paying bills, managing investments, selling property. Interestingly, this one can be used before the donor loses capacity, but only with their permission.
Okay. And the second type?
That's the health and welfare LPA. This covers decisions about medical treatment, care arrangements, daily routine. This one can only be used once the donor has lost the capacity to make those specific decisions themselves.
What about those older EPAs I sometimes hear about? Enduring powers of attorney.
Right, EPAs. You can't make new ones anymore. They were replaced by LPAs back in 2007. But any valid EPA made before then can still be used.
How do they differ from LPAs in practice?
The main difference is registration. An EPA only needs to be registered with the OPG when the donor starts to lose mental capacity. An LPA must be registered beforehand to be usable at all, even if capacity is lost later.
Okay, so if an attorney, using a valid LPA or EPA, approaches a lender for a mortgage, or maybe a further advance on behalf of the donor, what does the lender need to check?
They have a critical checklist. First is the POA document valid and in force. For an LPA, that means checking it's registered with the OPG. For an EPA, checking if it needs to be registered yet based on the donor's capacity.
Right, verification first.
Second, does the POA document actually give the attorney the specific power to borrow money on the donor's behalf? It needs to be explicit or clearly implied.
And third?
Is the purpose of the loan something allowed under the terms of the POA? The attorney can only act in the donor's best interests and within the scope of the powers granted.
Got it. It's a thorough check required.
Absolutely. Lenders have to be very careful when dealing with attorneys.
We've covered a lot of ground today, from the relatively less regulated world of corporate lending, where directors often end up carrying the can personally,
Through those personal guarantees?
to the really specific protections for individuals, like those frustrating rules for mortgage prisoners and the duties owed to vulnerable customers. And finally, the stark realities of bankruptcy and the importance of planning with powers of attorney.
It really highlights the constant tension, doesn't it, between facilitating finance and commerce and ensuring robust protection for individuals, especially when life throws curveballs. Understanding vulnerability, capacity. These aren't just tick box exercises for lenders.
Definitely not. And for you, the listener, maybe just recapping those key takeaways. Remember, corporate loans often skip FCA consumer rules. Mortgage prisoner rules are very narrow, and bankruptcy sticks on your credit file for a long 6 years.
And the planning aspect is key. That LPA, particularly for property and finance, is so important for ensuring someone you trust can manage things if you can't.
Which leads perfectly to our final thought for you today. We talked about how an ordinary power of attorney becomes useless the moment you lose capacity, and how a lasting power of attorney only works once it's registered. So here's the question. If you have an LPA set up your financial safety net, have you actually checked it's registered with the Office of the Public Guardian? Or is that vital activation step still undone, potentially leaving your affairs completely frozen exactly when your attorney needs to act? Something worth verifying, perhaps sooner rather than later.
A really crucial point to end on. Thank you for joining us for this deep dive.
We'll catch you on the next deep dive.